All right, so there's been a no. Look, it's all this is guys. This is really just a matter of God.
While the host of Fuddbusters is a lawyer, he is not your lawyer. If you pay him, maybe, either way you slice it, the video that you are about to watch is not to be construed as legal advice.
Right on. So there's a lot of confusion going on with this particular situation, and the headlines aren't really helping too much. Lots of you guys know, and we've talked about it here on the channel before, that the Florida company Rarebreed Triggers is doing their damnedest to stand up to the ATF. To quickly recap, ATF issued Rarebreed a cease and desist, telling them to quit making the FRT, asserting its position that the Rarebreed force reset trigger was a machine gun. Now, Rarebreed sued in the Middle District of Florida, among other things, seeking a preliminary injunction to keep ATF from making good on its threat to treat the FRT as a machine gun. The preliminary injunction was denied earlier this month in a fairly scathing order by Middle District Judge Carlos Mendoza. Now, though, the big fuss is over the case's sudden dismissal. Now, I'm not involved in this case, but I can do my best to try to explain what seems to be going on here from the filings. Lots of people think that this means Rarebreed is lost, or that it's some indication on the actual merits of the case, and that's just not what this is. First of all, as you can see, the case was dismissed without prejudice. What this means is that it does not act as an adjudication on the merits, or a judgment of who won. It just eliminates the case from the court's docket for now. Nothing, it seems to me, prevents Rarebreed from bringing this case again. It seems to me that this was a simple error of omission. I'll talk more about this error, but I want to hone in a bit more on what happens when a case is dismissed without prejudice. Now, unless you can have the dismissal reconsidered, which is possible here, you do have to bring the case again from the beginning. I've heard some people opining that this may have been a tactical decision, that they may be doing this to get a second bite at the preliminary injunction apple or something like that. I kind of doubt that. While yes, they may attempt to give the injunction another go in the new case, it isn't a common strategy. You're not guaranteed a new judge, and also it's kind of frowned upon. As for what seems to have actually happened here, if we simply read the dismissal, we can see it was done sua sponte. Now, sua sponte means that the court did it on its own, without involvement of Rarebreed or the government. This type of dismissal is generally only really brought when the parties make a clerical error and fail to follow the court's rules, hence why they don't involve a hearing and are done by the clerk. What this one involves is something really common now litigating in Central Florida, and it's setting up a case management plan. All parties here have to set up and agree to a certain plan that sets key milestones and due dates for certain stages of the lawsuit. This is to keep cases from clogging up the docket for ever. It seems here that the parties did not agree to and file a case management plan. I've heard a lot of people debating on whose fault this is, and the court isn't blaming either party here, because technically it is a responsibility of both of them. Of course, you're probably thinking, well, how could the government just ignore someone who's suing them and then see the case against them just dropped? Why wouldn't they just ignore every party? Well, it doesn't quite work like that. The two parties are supposed to get together and fill out one of these fairly simple forms. Now, if the defendant is refusing to cooperate, the plaintiff can basically tell teacher and bring it to the attention of the court. It seems here no such thing was filed, and Rarebreed likely simply forgot to pursue its obligation to set up a plan with the government. Do note that there is a footnote to this order which reads, if fault for noncompliance lies entirely with defendant, plaintiff may seek reconsideration on that basis. This means that if Rarebreed was trying to get the government to agree to a plan and just kind of getting the cold shoulder, Rarebreed could file a motion for reconsideration to bring that evidence to the court and avoid having to file a whole new case and pay new filing fees and everything like that. Now, these plans are a fairly new thing here, and I can totally understand letting the obligation slip. Still, though, this is not a huge development in the case. If anything, it's an annoying procedural speed bump. So don't freak out. Well, that's it for today, guys. Let me just say I really appreciate you watching and subscribing. It makes a huge difference for me. If you want to support me more than that, which is just so awesome, and I can't thank you guys enough, I have started up a Patreon and a Subscribe Star. There's benefits there, there's patron-only content, there's a Discord, and I'm hoping to add more stuff to that in the future. This kind of support will help enable me to make more content more regularly, something I'd love to be able to do. There's also a link to new and improved Fuddbusters apparel, stickers, and of course, the magic ATF ball. All of that stuff is in the description below, and it all helps out a huge amount. I really can't thank you guys enough. Thank you all so much for watching to the end and for your support. I'll see you next time, or if you join up on Patreon or Subscribe Star, I'll see you on the Discord. Y'all take care. Thank you.